everybody. This one is martial law as here and has been for decades. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for donation. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the commercial paper, the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for particulars. There's three kinds of martial law. There's full martial law proper, and martial law rule. And that's taken from the non-ratification of the 14th Amendment by Judge A.H. Ella to the Utah Supreme Court in the case Diet versus Turner. And he takes it from Ex parte Milligan, which is a U.S. Supreme Court case, Civil War era. Anyways, full martial law is a declaration of martial law is issued. Troops are put on the streets. It's used only during wartime. It's used on foreign country or when actually invaded by a foreign power or to put down an armed rebellion. Martial law proper is law of the armed forces when a captain tells a private what to do, and it's enforced by court-martials. And the martial law rule is the law of necessity and emergency. It allows the domestic use of martial law powers. It's used during peacetime, and it can continue for centuries during a military occupation. And so there's two ways that you can get martial law. This John Adams in 1826 says there are two ways to conquer and enslave a nation. One is by the sword, and the other is by debt. And so we're going to talk about the bankruptcy way. By the military occupation is in other videos. See the Texas and other American states are under a military occupation video, and see the Alberta and other Canadian states are under a military occupation video. The Revised Code of Washington Legislative Declaration for Civil Liberties Day of Remembrance. The legislature recognizes that on February 19, 1942, the President of the United States issued Executive Order number 9066, which authorized military rule over civilian law and lives. Evidence of martial law rule, military script is circulated for money. The action of Congress and the passage of the first Legal Tender Act was placed distinctly upon the ground of existing imperative need of government, and the Legal Tender Clause was urged and adopted as a war measure. That's martial law. That's Juilliard versus Greenman, U.S. Supreme Court. Evidence of martial law rule, military script is a forced loan. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States. Okay, again, that's U.S. Supreme Court. Juilliard versus Greenman. Federal Reserve notes, back in those days, they were talking about in 1862 and 1863, or U.S. Treasury notes, obviously. But Federal Reserve notes are legal tender too, and so that's still a forced loan. You're forced to loan the government money. That's exactly what it is. Congress, claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law in the United States and never discontinued it. The result was an extension of military and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the Civil Rights Acts, the legal tender laws, the 14th Amendment, etc., etc., etc. And that's all taken from that non-ratification of the 14th Amendment. And this is U.S. Senate Report 993-549, dated November 19, 1973. Since March 9, 1933, the United States has been in a state of declared national emergency. That sounds like martial law. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, and that's the same day that the emergency, declared national emergency happened. Okay, so think about it. They go bankrupt, and it goes into emergency rule. Anyways, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HGR 192, 73rd Congress in session, June 5th, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments. And as further evidence, the United States federal government exists today in name only. And that's U.S. Congressional Record, March 17th, 1993. And notice that part of what they're talking about there is suspending the gold clause, abrogating the gold clause, and so then the government doesn't have any money. At common law, only gold or silver coin are legal tender, and so it eliminates common law. The United States has been under dictatorial control since March 9th, 1933. That's that same report. Extraordinary powers have been delegated to the President, extraordinarily exercised by the Congress, ordinarily, I should say, exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing manners to rule the country without reference to normal constitutional processes. And that's a report of the Special Committee on the termination of the National Emergency War and Emergency Powers Act, but they really didn't terminate it all. Evidence of martial law rule, income tax collected under military authority, government seizes money without a court order, government seizes property without a court order, government seizes bank accounts without a court order. Don't forget to subscribe to this channel. Don't forget to like this video. Don't forget to click the bell next to the subscribe button so that you're notified when there's a new upload. And that's my front page of my channel, and notice the arrow is pointing to the bell. You click on that, a little pop-up will come up, and you can check a box and click OK, and that'll make sure you get notified of when I have uploads. As we have said, the federal personal income tax is collected under a military venue within a martial law jurisdiction. Federal Reserve notes are military scripts circulated within a military venue. The problem is the people don't understand how the entire United States is covered by a military venue. Under the Social Security Act, there's brought into existence 10 federal regional areas. These 10 federal regional areas are the same as a military base. And this is taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court, in the case Dyett versus Turner. I'm going to have a bunch of stuff from him in this. It's not unconstitutional to circulate military script on a military base, as the base is considered to be a military venue. Military script cannot circulate in the civil jurisdiction of the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas. And that's, again, the non-ratification of the 14th Amendment. The problem the Congress realized was while Congress could restructure the government agencies into federal regional areas, the people could not be identified to be within this military venue, but by their own consent. The solution was to create another military venue which would trick the people to voluntarily accept recognition that they're within a military venue. Congress solved this problem by creating the zip code. Bunch of crooks. The zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government, such as the IRS, and the return address of the federal agency is the district within the regional area the letter was sent from. And on the address of the citizen it was sent to is the national area in which he received correspondence from the IRS. In other words, the correspondence was sent from one federal regional area to one of the national areas, which are both military venues. Taxing districts are established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction. It becomes essential to distinguish between what is and what is not income according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot by legislation alter the Constitution from which it derives its power to legislate, and which within those limitations alone that power can be lawfully exercised. Income is derived from capital, the gain derived from capital, etc. Here we have the essential matter, not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value suffered from the capital, however invested, or employed and coming in being derived, that is received or drawn by the recipient for a separate use, benefit, and disposal. That is the income derived from property. Nothing else answers the description. So what they're saying here is it's corporate profits. And I used that in my first Supreme Court case. And you never see bold and underlined, but this case, everything that's underlined was also bold. And you go look it up in a law book, and that's the way it is. I've never seen that in any other case. U.S. Supreme Court. Evidence that there's a military occupation. Military scripts circulated for money. Police use rank structure of captain, lieutenant, sergeant. Police refer to non-police as civilians. Court presumes everything. Curfew is strictly under a martial law jurisdiction. State regional areas under metro government provide a military venue for the peace officers to enforce a martial law jurisdiction. We can't even begin to count the number of times judges, lawyers, and statesmen said there isn't any common law anymore. It's been replaced by statutes. They'd be more truthful if they said there isn't any common law anymore. It's been replaced by martial law. And that's exactly right. So that's why there's no statute, or I should say that's why there's no common law. It's all statutes. That's evidence of the martial law rule. There's no common law of the United States as contradistinguished from individual states, and courts of the United States, especially instead of administering common law or any particular system, conform to law of states where they are situated. And this is, there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its commands or crimes. Okay, so that's all evidence of martial law rule. Under Texas law, no act or omission is a crime unless made so by statute. This is all evidence of martial law rule. Legislature may create an offense and in the same enactment provide exceptions to its application. Everything is an admiralty. A root of error doth not lie upon a sentence in the admiralty, but an appeal. And that's cited in Tomlin's Law Dictionary, 1835 edition, under the definition of admiralty. But they're citing Book 4 on Coke's Institutes and the Laws of England, which goes back to the 1500s. Appeals are an admiralty. That's why it's called a court of appeals. It's the same thing that precipitated the War of Independence. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism reduces, and this is taken from the Causes and Necessity for Taking Up Arms, 1775. And Ellett, in his book Non-Ratification of the 14th Amendment, says it's the same thing, only slightly different, and in a different way, I should say. In the meantime, the civil law was the form of law imposed on the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And if you ever get in one of these courts with one of these bail priests, one of these kangaroo courts, they'll tell you, I can do anything I want in here, and they're 100% correct. And if you start arguing the Constitution, they'll tell you the Constitution doesn't apply in here, and I don't want to hear another word about it. And they'll be right about that too, because it's all martial law. This is a Georgia Department of Driver Services letter, and it's been sanitized. It's a 3-page letter, so the important part here is on page 2. The statute creates a rebuttable presumption of residency for anyone who meets the following criteria. Any person who seeks employment or engages in any trade, profession, or occupation in Georgia, or enters his or her children to be educated in public and private schools in Georgia within 10 days after the commencement of such employment or education, or any person who, except for infrequent brief absences, has been present in the state for 30 days or more, provided, however, that no person shall be considered a resident for purposes of this chapter unless such person is either a U.S. citizen or an alien with legal authorization from the U.S. Immigration Service. Okay, so the point being is that they're talking, that doesn't say anything about state citizens. Okay, you can be a state citizen and it doesn't mean a hill of beans. Okay. This is, again, a federal statute, okay? Even though it's a state statute, it's a federal statute. We're going to talk about that in a few minutes. and it's signed by the General Counsel for this Georgia Department of Driver Services. Anyways, and so the point I want to bring out, the statute creates a rebuttable presumption. Okay, everything is on presumption. Remember, we talked, that's one of the things of martial law, of residency for anyone who meets the following criteria. However, no such person shall be considered a resident for purposes of this chapter unless such person is either a United States citizen or an alien with legal authorization from the U.S. Immigration and Naturalization Service. And now a little diversion, announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 a month because it avoids the advertising only. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit. Originally, I was going to have exclusive material on there, but I couldn't think of what I'd want to have on there exclusively because of my agenda to expose these Satanists and their fraud. And so there's nothing on there that's exclusive. There is a Arlington private information share, but it really doesn't have anything that any other private information share doesn't have. So that's it. And so yeah, I wish I could tell you more. The only thing that I can guarantee is it'll have no advertising. If you want to make a donation, I mean, that's a great way to make a donation. It doesn't have to be a lot, but a lot of people making small donations, it can add up pretty fast. And so it's all appreciated. I'm currently publishing 5 videos a week. Some people had trouble finding the channel. A link to the channel is at the bottom. When I get my subscribers over a certain level, then I'll be able to have a custom name. But right now, I don't get that. Anyways, and this is the front page of the channel, and the link to the channel is at the top. And also, some people sent me a donation for $1.99. At least I'm guessing they did. I sent them an email and asked them if they wanted me to sign them up, and they never did respond. I offered to refund it if they did. Because I have absolutely no control over the subscribers on this channel. I can't even see them all. I can see some of them, but I can't see them all. And so if you want to subscribe, I cannot do it for you. You're going to have to click on the Start Free Trial, and YouTube is going to want probably some payment arrangements or something. I don't know. But so it's out of my control. That's completely out of my control. Anyways, back to the topic at hand. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. The point I'm going to go into here is that this is all under martial law, and it's all voluntary. Where an action is founded entirely upon a statute and the only object is to recover a penalty or forfeiture, such action is a penal action. The words penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. Okay, so they assault you with one of their contracts is what they do. A penal action is one founded entirely on statute, brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while remedial action is one brought to obtain compensation or indemnity. And so a penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand, closely related to criminal prosecutions. On the other hand, the other two actions for private injuries in which a party agreed may by statute recover punitive damages. So again, penal actions and offenses, okay, when you do an offense, well, that's a penal, okay, that's a penal action, and so it's a civil suit, okay, and that's why that when you ask the bail priest in the so-called court the nature of the action, he'll say it's quasi-criminal. It's really a lawsuit, and there's just a whole bunch of reasons. This is all a fraud. It's a contract. That's the reason there's no lawful warrants, okay? They do not issue lawful warrants. There's no such thing. They issue a capias, which is a debt instrument, and they go and everybody's getting royalties on the thing, okay? Whoever arrests you okay, is getting a royalty on it. All of that stuff. That's why you need to do the estoppel certificates, okay? You got to put them into estoppel. And you watch my video on do-it-yourself estoppel certificates. Anyways, martial law is really no law at all. It's a dictatorship. What's called proclaiming martial law is no law at all, but merely for the sake of public safety in the great and circumstances of great emergency, setting aside all law and acting under military power, a proceeding which is required to be followed by an act of indemnity when the disturbances are at an end. Well, they haven't ended for 150 years. And that's an attorney general's opinion of 1857, but it's cited in Diet versus Turner, this non-ratification of the 14th Amendment. The right to trial by jury in civil cases guaranteed by the 7th Amendment, the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileges and immunities of citizens of the United States guaranteed by the 14th Amendment. Remember, we talked, this is all about U.S. citizens. Against abridgment by the states, and in effect the same decision was made in respect to the guarantee against prosecution except by indictment or grand jury contained in the 5th Amendment, and in respect of the right to be confronted with witnesses contained in the 6th Amendment. Martial law is the public law of necessity. Necessity calls it forward. Necessity justifies its exercise. Necessity measures the extent and degree to which it may be employed. That necessity is no formal, artificial, legalistic concept, but an actual and factual one. It is the necessity of taking action to safeguard the state against insurrection, riot, disorder, or public calamity. What constitutes necessity is a question of fact for each case. And that's a practical manual of martial law, Black's Law Dictionary, 8th edition. Martial law is nothing more, nothing less than the application of the common law doctrine that force, to whatever degree necessary, may be used to repress illegal force. Martial law is the public right of self-defense against a danger threatening the order or the existence of the state, where the ordinary civil authorities, the police, are unable to resist or subdue a disturbance. Additional force, military in nature, may be applied. The extent of military force used depends on each instance upon the extent of the disturbance. And again, that's Black's Law Dictionary, 8th edition. The power of the admiralty jurisdiction is as extensive upon land as upon water. The Constitution makes no distinction in that respect, and if the admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, may be extended to the lakes under the power to regulate commerce, it can be with the same propriety upon the same construction be extended to contracts and torts on land when the commerce is between different states. And that's U.S. Supreme Court. It may embrace also the vehicles and persons engaged in carrying it on. It would be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers or merchandise from one state to another, over the persons engaged in conducting them, and deny to the parties the trial by jury. Again, this is all U.S. Supreme Court. Now, the judicial power in cases affecting admiralty and maritime jurisdiction has never been supposed to extend to contracts made on the land and to be executed on land, but if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason would justify the same exercise of power on land. U.S. Supreme Court. Next to revenue, taxes itself, the late extensions of the jurisdiction of the admiralty are our greatest grievance. The American courts of admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England a dangerous innovation if the trial of any matter on land was given to the admiralty. And that's 1852. Prize. A vessel or cargo captured at sea or seized in port by the forces of a nation at war, and therefore liable to be condemned or appropriated as enemy property. That's Black's Law Dictionary. A prize court having jurisdiction to adjudicate the captures made at sea in time of war. And this is Title 18, Part 1, Chapter 1, Section 7, Special Admiralty, Special Maritime and Territorial Jurisdiction of the United States termed. The term Special Maritime and Territorial Jurisdiction of the United States as used in this title includes the high seas or any waters within the Admiralty Maritime Jurisdiction of the United States and out of the jurisdiction of any particular state, and any vessel belonging in whole or in part to the United States or any citizen thereof. Okay, so that means if you got your vehicle registered or any corporation created by or under the laws of the United States, that means any corporation, or of any state, territory, district, or possession thereof, when such vessels within the Admiralty maritime jurisdiction of the United States and out of the jurisdiction of any particular state. That means U.S. citizens. Any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, confidence games, and attempting to commit or compounding any of the foregoing crimes, addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crimes. That's 27 CFR section 7211. The Admiralty was the highest antiquity, exercised a very extensive criminal jurisdiction. Admiralty courts have jurisdiction over contracts and torts and other special cases. Criminal jurisdiction in the United States is wholly statutory. Okay, remember it has to be by statute. We talked about that earlier. It is natural to consider the vessels of a nation as part of its territory, though at sea, as the state retains its jurisdiction over them. This is the doctrine of the law of nations. It is true that in the criminal jurisdiction of the United States is in general based on territorial principle, and criminal statutes of the United States are not only implication given an extraterritorial effect. And again, that's U.S. Supreme Court. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, act as mere clerks of the involved agency. There are no judges. It is the accepted rule, not only in state courts, but in federal courts as well, and when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes. As a clerk, they're bought and paid for. Okay? The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century so as to continually harass and shamefully enrich the crown. Okay, that's how they proceed in an admiralty proceeding. The oppressive use of this mode of prosecution by information occasioned struggles to procure a declaration of its illegality. Well, it's not illegal today. The right to be represented exists only in a military court. The accused has the right to be represented in his defense before a general or special court-martial at an investigation under Section 832 of this title, as provided in this subsection. And the forms and modes of proceedings in causes and equity and of admiralty and maritime jurisdiction shall be according to the civil law. Admiralty, civil law, it's all civil law is Roman law, it's Roman cult. Brown, Volume 2, 100, lays down the rule in general terms that at the Admiralty acts only in rem, and no person can be subject to that jurisdiction but by his consent, expressed by his entering into a stipulation. They have to get you into a contract. In Krebel's report, quoted by Brown, it's expressly stated that without a stipulation, the Admiralty has no jurisdiction at all over the person. It is well known that in civil cases, the courts of admiralty, equity, and admiralty juries do not intervene, that the courts of equity use trial by jury only extraordinary cases to inform the conscience of the court. And so if there's a jury there, it's a show trial. Commercial law is a subset of maritime law. There must be uniformity in maritime law. The principles in maritime laws are applicable to commercial law, and therefore there must be uniformity in commercial law. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly of herself, more properly called municipal law, to distinguish it from the law of nature and from international law. That's Black's Law Dictionary, 4th edition. This is all coming from the Roman cult. Title 15, United States Code, Section 44. A corporation shall be deemed to include any company, trust, so-called Massachusetts trust or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest, and any company, and it goes through the same definition except it doesn't have shares of capital stock or certificates of interest. So that's the Sesticate Trust right there. And now a little diversion, CubeYard.com. For great custom websites, domain names, hosting, go to CubeYard.com. Use coupon code CY172 for 20% off your first order. CubeYard.com, your source for websites, domain names, and hosting. Admiralty law, the terms admiralty and maritime law are virtually synonymous. United States District Court is not a true United States court established under U.S. Constitutional Article 3 to administrate the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted on Article 4, Section 3, making all needful rules and regulations respecting territory belonging to the United States. And that's Balzac, U.S. Supreme Court, Balzac versus People of Puerto Rico. Roman cult equals military uniform equals martial law. The wearing of clerical dress or religious habit by lay people is liable to the same penalty in the state as the misuse of a military uniform. At common law, a judge would be wearing a business suit. You don't see judges wearing business suits these days. When a state forms a constitution which is approved by Congress, it is to stop to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department, okay? And so the point being is that when the Satanists in Washington get up and say, well, this amendment's been ratified, then the courts can't look into it. That's why they say the 14th Amendment is a political issue. They won't rule on it. They'll say it's a political issue. The amendment reversed and annulled the original policy of the Constitution, the 14th Amendment. Even the U.S. Supreme Court operates under authority of the President of the United States, so there's no separation of powers. This is Rule 45. The U.S. Supreme Court rules of procedure. All process of this court issues in the name of the President of the United States. Even state courts are actually federal courts because they have U.S. military flags in them. If they have a corporate seal, it's a corporate court. If they have a coat of arms, it's martial law. The law of the flag is maritime law, the law of the nation whose flag is flown by a particular vessel where it's registered. A ship owner who sends his vessel into a foreign port gives notice by his flag to all who enter into contracts with the master that he intends the law of that flag to regulate such contracts, and that they must either submit to its operation or not contract with him. In personam, judgment. So a judgment or decree is said to be in rem when it binds third persons, such as the sentence of a court and admiralty and a question of prize or decrees of nullity or dissolution of marriage. Okay, so divorce courts are all admiralty. A decree of a court in a foreign country as to the status of a person domiciled. So the important thing is divorce courts are all admiralty. Brutum fulmen. Okay, remember if they're bought and paid for a clerk, if it's not a court, then it means nothing. Okay, and brutum fulmen, an empty noise, an empty thread, a judgment void upon its face, which is in legal effect no judgment of all, and by which no rights are divested, and from which none can be obtained, neither binds nor bars anyone. It's brutum fulmen. That's all these courts do nowadays is brutum fulmen, and they sell you into slavery based on that. Not every action by any judge is an exercise of his judicial function. It is not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void and of no legal force and effect. And again, so they lose subject. That's a void judgment. This has been going on for centuries, if not millennia. It's the same thing that precipitated the Magna Carta. It's the same thing that precipitated the War of Independence, and it's probably responsible for countless wars and revolutions. The Declaration of Independence, he's affected to render military independent of and superior to the civil power. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury. Have to understand the Declaration of Independence is basically a list of grievances. For abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, martial law, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule, martial law, into these colonies. He has abdicated government by declaring us out of his protection and waging war against us, martial law, for protecting them by a mock trial, martial law. The Magna Carta is full of evidence that it was precipitated by martial law rule. We will appoint justices, bailiffs, constables, bailiffs, only such as know the law of the realm and mean to observe it well. Well, obviously they weren't observing it well, were they? That means martial law. They were doing whatever they felt like doing. To none will we sell, to none will we refuse, delay, right, or justice. Well, They were selling justice just like they're selling it today. They were refusing justice just like they're refusing it today. They were delaying it just like they delay it today. There are chapters describing how they were stealing people's woods, people's horses, carts, and more. Law merchant is private international law. They're violating Chapter 38 of the Magna Carta. No bailiff for the future shall put his own unsupported complaint, put anyone to his law without credible witnesses. So they were basically assaulting you with their law, and that's what they do in the courts nowadays. They assault you with their Uniform Commercial Code. No freeman shall be taken or imprisoned or seized or exiled in any way, destroyed, nor will we go upon him, nor send upon him, except by the lawful judgment of his peers or by the law of the land. Well, they were assaulting people in all sorts of ways, and that's they were imprisoned, they were exiled, they were destroyed by ways that were not the law of the land or your peers. That's why they put it in there, because that's the stuff that was going on. There are certain words that are used in martial law. Commerce, resident, sovereigns inhabit. A home is an abode. You don't reside. Traffic is commercial. Commissioners, commercial. Drive. Sovereigns travel with their private property. Human, you're a man, a living soul. Liberty, you have freedom, not liberty. Liberty is something you get from a ship. Mail, as we use the post or a postal address. Transportation. Spouse is a person. I don't have a spouse. I have a wife. My wife and I are joined in holy matrimony, but we're not married. Any word that is for a person, trustee, trustor, beneficiary, anything to do is set up for trusts. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. One or the other would be treason to the Constitution. Almost every nation on the planet's under martial law. Almost every nation on the planet is bankrupt. Bottom line, all of this martial law stuff is for Ford and General Motors. If you are a Ford or GM employee, then you are a slave for Ford or GM. If you want to be free, then we the people have to quit letting Ford and GM run the country. Did you give up your God-given rights for some satanic privileges? In Downs versus Bidwell, the dissenting opinion, Justice Marshall Harlan said, 2 national governments exist. One to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. Why do you think Nancy Pelosi, as Speaker of the House of Representatives, say they have to pass legislation so they can find out what it says? What a scam. And so that's exactly what's going on. Whose duty is it to protect the Constitution? The courts have ruled that the government is not the protector of the Constitution. If the government is not the protector of the Constitution, then who is? It is not the function of our government to keep the citizen from falling into error. It's the function of the citizen to keep the government from falling into error. And we do that by challenging what they're doing. And now another little diversion. Bankster Thieves 1, 2, and 3. Check out my other videos. Churchianity series. Bankrupt corporate so-called governments. Bar members 1 through 3. Do-it-yourself how not to volunteer for the selective service in the draft. Martial laws here. Do-it-yourself no income tax. Do-it-yourself no sales tax. Do-it-yourself traffic stop. Do-it-yourself free mail. Do-it-yourself kangaroo courts 1 through 9. And back to the topic at hand. Resistance to tyranny is service to God. Do you know who you are? When plunder becomes a way of life for a group of men, they create for themselves in the course of time a legal system that authorizes it and a moral code that justifies it. If you have 10,000 regulations, you destroy all respect for the law. Did you give up your God-given rights for some satanic privileges? But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to purely personal privileges. Rather, they assume the rights and duties and privileges of the artificial entity or association over which they're agents or officers, and they're bound by its obligations. Okay, and that's U.S. Supreme Court. So when you get up there in that kangaroo court and you say, yes, I am the name, well, you just entered into a contract. Did you give up your God-given rights for some satanic privileges? Uniform Commercial Code equals Unidroit equals Roman cult. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until the evidence is introduced that supports a finding of its non-existence. UCC 1-206. And this is a Texas version of the Uniform Commercial Code. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted unless specifically denied in the pleadings. If the validity of a signature is denied in the pleadings, the burden of establishing validity is on the person claiming validity, but the signature is presumed to be authentic and authorized. And so what they're doing is they're forging your signature onto a contract and then presuming that it's accurate. And unless you know that's what's going on, they're going to sell you into slavery is what they're going to do. The following rules apply in an action on a certificated security against the issuer unless specifically denied in the pleadings. Each signature on a security certificate or in a necessary endorsement is admitted. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine or authorized. Again, they forge your signature onto a contract and then they sell it onto Wall Street. People have found their criminal cases circulating on Wall Street. At Fidelity Investments, these Roman cult Satanist bar member whore masquerading as judge forge your signature onto a contract and then presume it's authorized and authentic. And who's going to call a judge a liar? That's how they're populating the prisons. Carl Lentz brought up the issue of forgery against CPS when they stole his son in a successful one-page lawsuit. And that was after 11 years. They took his son when he was newborn, and he got him back when he was 11 years old. See the judicial whores video. Did you give up your God-given rights for some satanic privileges? He, the convicted felon, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. They are selling you into slavery. That's why they have to do martial law, so they can get rid of that pesky little problem about common law, because at common law they would be put to death. This is Deuteronomy 24:7. If a man be found stealing any of his brethren of the children of Israel, and make merchandise of him, or selleth him, then that thief shall die, and thou shalt put evil away from among you. So the question I have for people that are watching this right now is, are you Christian or are you something else? I mean, I thought America was a Christian nation. Obama used to go around saying America wasn't a Christian nation, and I'm starting to think that might be the case. Mark Passio says that 2/3 of us are practicing Satanists, and I think Mark Passio is being generous. I think it's more like about 90%. Most of these so-called Christians out there don't have a clue. International law is a subset of canon law. International law started with the Roman cult. Unidroit stands for the International Institute for the Unification of Private Law. Unidroit is located about 100 yards from the Holy See. Unidroit controls and governs the Uniform Commercial Code. Through Unidroit, the Roman cult has seized control of all courts. The Roman cult bar members are already all officers of the court, so it's not hard for them to go and seize it. See bar members videos 1, 2, and 3. The United Nations is owned and operated by the Crown and the Roman cult handlers. See, the Crown is owned and operated by the Roman cult video. See, the United States is a Crown colony, and the Crown owns and operates the United Nations 1 and 2 videos. Unidroit is coming from the United Nations. See, the Roman cult slave camp scam 1 video. United Nations maintains the International Law Collection, which is also coming from the Roman cult. They're using Roman cult's international law rule to assault us with their fraudulently fictitious Sestake Trust U.S. citizen slave. That's exactly what these Satanists are doing. Here's the international law rule, adopted for areas under federal legislative jurisdiction. Federalizes state civil law, including common law. The rule serves to federalize not only the statutory, but the common law of a state. State and federal venue discussed. The civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws, and a cause arising under such laws may be brought in or removed to a federal district court under sections 24 or 28 of the former judicial code. all state laws are actually federal, okay? And this is taken from Jurisdiction over Federal Areas Within States, Report for the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas Within the States, Part 2, a text of the law of legislative jurisdiction to the Attorney General, submitted to the Attorney General and transmitted to the President, June 1957. That's page 158. Actually, it's 158 through 165. So if you're a U.S. citizen, all state laws are actually federal, okay? If you're a state citizen, none of them meet a hill of beans. Remember, they get rid of common law, and then they have to have statutes. If it's not a statute, it's not a law, and that's all U.S. citizens. And here's why. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, states' cases between citizens of the district and those of the states were not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power, that's Admiralty Maritime Law, nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. And there's lots of cases that talk about that. This is the Vatican's Holocaust, the sensational account of the most horrifying religious massacre of the 20th century. You think this is unique for this Roman cult? They do this on a regular basis. This is by Averell Manhattan, a Knight of Malta. Averell Manhattan was the world's foremost authority on Roman Catholicism and politics, a resident of London during World War II. He operated a radio station called Radio Freedom, broadcasting to occupied Europe. He was the author of over 20 books, including the bestseller The Vatican and World Politics, twice Book of the Month, and going through 57 editions. He was a Great Britain who risked his life daily to expose some of the darkest secrets of the papacy. His books were #1 on the Forbidden Index of the past 50 years, and the editor added in that in 2006 it was 70 years. I guess that means it's 80 years now. And this is the preface to the American edition. The Vatican Holocaust is not a misnomer, an accusation, and even less a speculation. It is a historical fact. Rabid nationalism and religious dogmatism were his two main ingredients. During the existence of Croatia as an independent Catholic state, over 700,000 men, women, and children perished. Many were executed, tortured, died of starvation, buried alive, or were burned to death. Hundreds were forced to become Catholic. Catholic padres ran concentration camps. Catholic priests were officers in the military corps, which committed such atrocities. 700,000 in the total population of a few million proportionally would be as if 1/3 of the USA population had been exterminated by a Catholic militia. What has been gathered in this book will vindicate the veracity of these facts. Dates, names, places, as well as photos are there to prove them. They should become known to the American public, not to foster vindictiveness, but to warn them of the danger which racialism and sectarianism, when applied with religious intolerance, can bring to any contemporary nation, whether in Europe or in the New World. This work should be assessed without prejudice and as a lesson, but even more vital as a warning for the future of the Americans, beginning with that of the USA. And that's Averell Manhattan, 1986. And then an editor's note: an armed Serbia could have easily prevented this Holocaust. Thank God for the Second Amendment to the Constitution, which guarantees the right to bear arms. Freedom of religion and an armed citizenry go hand in hand, and is the only guarantee that this won't happen in the U.S. It is, and then the editor's note, it is the Vatican's one world government that doesn't want you to have the right to own arms or use any means to defend yourself. And is any doubt that the UN is owned and operated by the Roman cult? And I want to say right here that it should not reflect, or does not reflect, upon people that happen to be Catholic. Notice they went and murdered a whole bunch of Catholic people here, and some of my best friends are Catholic, and they're feeding me this information. And so it's the Roman cult that's responsible. Anyways, Roman law equals Roman cult equals Satanism. Mark Passio, the former Satanist priest, talks about the pillars of Satanism, and one of the pillars is moral relativism, which is we decide what's right or wrong today, and tomorrow it'll be something different. And that's exactly what these Baal priests and these Roman cult courts do when they sit there and play stupid, and they sell you into slavery. That's satanic. It's a satanic religious ceremony. These people are Satanists. And we need to, this is the war in the book of Revelations that's talked about, and we need to put an end to this Satanism. The citizens, and there's always been two classes of citizens. It's all dependent upon the two classes of citizens. The citizens of each state shall be entitled to privileges and immunities of citizens in the several states. And that's U.S. Constitution, Article 4, Section 2, Clause 1. And Leviticus 19:34, but the stranger that dwelleth among you shall be unto you as one born among you, and thou shalt love him as thyself, for you were strangers in the land of Egypt. Love ye therefore the stranger, for you were strangers in the land of Egypt. Deuteronomy 10:19. The point being is that's how they enslaved the children of Israel, and that's how they're doing it again today. That's exactly how they did it, and that's, 4,000 years ago almost. The rights of sovereignty extend to all persons and things not privileged that are within the territory. They extend to all strangers resident therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they're within his territory and owe a temporary allegiance in return for that protection. Again, that's U.S. Supreme Court, 1873. Two classes of citizens, the strangers and those born in the land. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. The so-called 14th Amendment is unconstitutional. See the video. The so-called 14th Amendment is unconstitutional. Taxpayers are not state citizens. Did you give up your God-given rights for some satanic privileges? State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair those rights. Watch my Do It You Know Who You Are series, the playlist. The state citizen is immune from any and all government attacks and procedure absent contract. Or as the Supreme Court has stated clearly, every man is independent of all laws except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent. You can be a state citizen without being a U.S. citizen. The rights of individuals are restricted only to the extent that they've been voluntarily surrendered to the citizenship by the citizenship to the agencies of government. Did you give up your God-given rights for some satanic privileges? The people are sovereign, are not bound by general words and statutes restrictive of prerogative, right, title, or interest unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. It will be admitted on all hands that with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective state. Did you give up your God-given rights for some satanic privileges? A sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right against the authority that makes the right, and that's cut off. But anyways, at the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but the citizens of America are equal as fellow citizens and joint tenants in the sovereignty. The people of a state are entitled to all the rights which formerly belonged to the king by his prerogative. Watch my Do You Know Who You Are playlist. Did you give up your God-given rights for some satanic privileges? And this is Downs versus Bidwell. Eliminating then from the opinions of this court all expressions unnecessary to the disposition of the particular case, and gleaning therefrom the exact point decided in each, the following propositions may be considered as established. That the District of Columbia and the territories are not states within the judicial clause of the Constitution giving jurisdiction to cases between citizens of the different states. In other words, there are no courts. If you're in the District of Columbia and the territories, there are no courts, okay? It's a kangaroo court. The District of Columbia and the territories are states, as that word is used in treaties with foreign powers with respect to the ownership, disposition, and inheritance of property. And so they're talking about the Sestakay Trust, number one, and that's why they do call they say United States and the states, okay, and then they'll say and they'll even spell out the states: Guam, American Samoa, and Puerto Rico. But they don't say Texas. They don't say Arizona, okay? And if people don't understand this principle, they think that it is Texas or Arizona. And that the territories are not within the clause of the Constitution providing for the creation of a Supreme Court and such inferior courts as Congress may see fit to establish, right? So there are no courts in the District of Columbia or the territories. It's all a fraud, okay? It's a kangaroo court. The United Nations has nothing to do with state citizens. Did you give up your God-given rights for some satanic privileges? United States participation with the United States applies only to the U.S. citizens. There are no courts in the District of Columbia and the territories. There are only kangaroo courts. A kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. And so the bottom line is that this is all satanic, okay? Martial law is voluntary. You don't have to volunteer in. You have to understand how they're getting you to volunteer in and quit volunteering, okay? Watch my video, Everything's an Illusion, and quit volunteering. And Do You Know Who You Are? Watch the Do You Know Who You Are playlist. All this martial law stuff is voluntary. And we have to quit letting Ford and GM run the country. And if you're not working for Ford and GM, then it has nothing to do with you. And even if you are working for Ford and GM, it's only when you're at work. And other than that, thanks for watching. Spread the word. Have a great day.